antiquarian who travels through the land between the borders of then and now. We follow him over the field and hill.
Welcome to Civil Procedure Online. Hey, I'm your host, Dennis Crouch, the modern antiquarian. Hey, you see an image of Ken Lopez, bookseller. You can find his website at lopezbooks.com. Hey, the topic for this little video is jurisdiction created by internet activities. This is obviously a changing doctrine as our use of the internet and networked communications becomes more and more pervasive, as business online becomes deeper and deeper into our pockets and into our daily life. The questions regarding minimum contacts also become thornier. Abdouch versus Lopez. This is a Nebraska Supreme Court case from the year 2013. Lopez is from Hadley, Massachusetts. In Hadley, he operates his website where he sells lots of fine books, antique books, and manuscripts. One such book that he sold is called The Revolutionary Road by Dick Yates, 1961 book. This particular version had an inscription from the author that said, quote, "For Helen Abdouch, with admiration and best wishes, Dick Yates." Lopez apparently did some internet research and figured out who Abdouch was, the executive secretary of the Nebraska organization helping to elect John F. Kennedy back in 1961. Now, the gift here was in August of 1963, just a couple of months before Kennedy was shot and killed in November of that year. Apparently, the book was stolen from Abdouch. There's no indication that Lopez had anything to do with the theft, but he did eventually obtain a copy, and then he sold his copy. Now, in your property law class, you'll talk about some stolen goods cases, and depending upon the situation, Lopez might be seen as a bona fide purchaser, and if so, would have no liability even if this was stolen goods. But Abdouch did not sue him for stealing the book, but rather for writing about her on his website and trying to make money from her story. This was a privacy violation under Nebraska state law. Let's look at the statute here. We have a cause of action under Nebraska code called invasion of privacy, which says any person that exploits a natural person, that person's name, picture, portrait, or personality for the purpose of advertising or commercial purposes shall be liable for invasion of privacy. Really broad statute here. Now, when you take a free speech class, you'll learn that this statute might not be enforceable to the full extent as it's written, but still it has some teeth. So it's unclear whether or not Abdouch would win on the merits, but that's for your torts class. Lopez raised the defense in Nebraska state court that the state courts have no personal jurisdiction over him because he's from Massachusetts and does not have minimum contacts with the state. Now, Abdouch does admit that he has sold books to individuals in the state. Out of $3.9 million in sales over the past few years, he had collected $600 from books sold into Nebraska. In addition, there are 2 people who asked to be on his mailing list, and they were in fact added 2 people from Nebraska. That said, Lopez's website is a site where any person from around the country, perhaps around the world, can peruse and find what's going on, can look through all of the material without restriction, including people from Nebraska. If people from Nebraska want to buy books, etc., they're able to via this online store. It's an interactive website. Now, we know that every case is going to be analyzed under international shoe for traditional notions of fair play and substantial justice. But in this case, the court cited to 2 leading cases, helping us think through when does internet-based business create sufficient minimum contacts. The first case is the Zippo case, a trademark case out of the Western District of Pennsylvania. This is a district court case, but because it was an early internet personal jurisdiction case, it continues to be a leading case. In this case, the district court wrote about a sliding scale regarding levels of interactivity of a website and said those levels of interactivity and the amount of whether this is doing business over the internet is helpful for determining whether a court has personal jurisdiction over the operator of the website, even in states where that website operator is not a resident. Or the court in Zippo noted in particular that highly interactive sites where the defendant is doing business over the internet suggests that personal jurisdiction is appropriate. In this case, the Nebraska court, although not required to follow Zippo, looked at Zippo and considered its applicability, noting that Lopez is certainly doing business across the internet with a somewhat interactive site. In the end, the court effectively refused to follow Zippo, at least a broad statement of Zippo's holding. I will note that Zippo has substantially lost favor, and although courts continue to regularly cite it, they also regularly refuse to follow. The second approach the court took was to look at the Calder Effects Test. Now, Calder versus Jones is a pre-internet case, but it's regularly cited and regularly followed in internet jurisdiction cases. If you see the image in the upper right, you can see Shirley Jones, who's the mother in the Partridge Family.
Meet everybody and hear us singing. There's nothing better than being together when we're singing. Five of us and Mom working.
In the bottom right corner, you see the National Enquirer, an American tabloid. In the issue you see here, you'll note that Adam and Eve were actually astronauts. But for this case, there was an article regarding Shirley Jones indicating that she was an alcoholic. Jones contended that that was absolutely false and sued the National Enquirer, including the author of the article, Ian Calder, for libel. Now, the article was published in Florida, albeit for nationwide distribution. Calder argued that he had no direct relationship with California and shouldn't be hailed into court in California. He was just sitting there in Boca Raton typing up this article, although he did make some phone calls to California to sources to make sure he was writing the truth, or something close there too. In its decision here, the Supreme Court found that California jurisdiction was appropriate and mentioned something that some of our prior cases have talked about, an exception regarding intentional torts. When someone commits an intentional tort directed at a state, that's typically going to be enough to create personal jurisdiction. Now, in Calder v. Jones, the Supreme Court created what's now known as the Calder Effects Test. The court said when you have an intentional act that is aimed at the foreign state, and the actor knows that it will likely cause harm primarily in the forum state. When we have these elements, that's enough for a district court to claim personal jurisdiction over an out-of-state defendant. In this case, the Nebraska Supreme Court analyzed Calder and found that under Calder, there should be no personal jurisdiction. In particular, we note that Lopez did not direct his acts towards Nebraska. Now, the direction of acts is a little bit tricky. If we know, right, in Calder v. Jones itself, this is a publication for nationwide distribution. They're not just publishing in California, but they're publishing around the world. Likewise, in Lopez, we have a website that's available around the world. But the kicker for the court in Nebraska was that there was no evidence that Lopez knew that Abdouch was a resident of Nebraska. In fact, it appeared that he assumed that she was dead, since the incident in question, the 1960s, were 50 years in the past. Without that link to Nebraska, then there's no reason to hold Lopez under the Nebraska court's fire. Now, for a different day, we'll save a little bit of an issue here, in that Abdouch actually alleged that Lopez knew that she was a Nebraska resident. And if you remember, he did do this internet searching and had known that at one time she was the head of the Nebraska election campaign. So that calls into question some issues regarding procedure, and when we're on a motion to dismiss for lack of jurisdiction, how should the court weigh the allegations? And if we have an open question like this, should the court allow some amount of discovery to determine whether or not jurisdiction is appropriate? Now, the last case I want to mention is in the notes following Abdouch. It's Walden v. Fiore, 2014 Supreme Court case. Fiore is a professional gambler and was returning to her home in Las Vegas from a tournament in Puerto Rico. She had a suitcase full of $97,000. That included both her gambling winnings and also her bank. If you're going to go gambling, you got to take some cash with you to start the betting. When she arrived in the United States, a DEA agent, Walden, confiscated the money after concluding that such a large amount of money must be drug-related. Walden subsequently drafted a false affidavit that supported what's known as a civil asset forfeiture. Don't get me started on civil asset forfeitures. Just Google it. Once she learned what Walden had done, she sued Walden for damages. But she's from Las Vegas. She sued in district court in Nevada. But the seizure had taken place in Georgia. At the time, though, Walden knew that she was headed back to Nevada. That's where she was headed. That's where she was from. Fiore argued the Calder Effects Test, saying that Walden committed an intentional tort by drafting and filing the false affidavit. At the time, he knew that she was a Nevada citizen, and in fact, she was already back in Nevada. And he also knew it would primarily cause her harm in that state. It looks like that Calder Effects Test was met. When the case got to the Supreme Court, the court essentially held that it's not so simple, that our three-step statement of the test overly simplifies the question. Just looking at the effects in this case were insufficient. The court distinguished Calder a few ways, noting in particular the wide distribution of the National Enquirer and the fact that the authors had made additional calls to California. So under Fiore, maybe we need effects plus.
I'm a gambling man, man, man. I'm a gambling man, man, man. I'm a gambling man, man, man. I'm a gambling man.
Thanks so much for listening. This has been Civil Procedure Online.
Going down into Georgia to knock down my last game. I'm a gambling man, man, man. I'm a gambling man.